Everyone. We want to thank you and welcome you to our fourth and final part of our ECI Coronavirus Best Practices series. Today, our CLE is on family law, dealing with the impact of the coronavirus on child visitation. We have a wonderful group of panelists. I'm going to introduce them before we turn it over for this great presentation. Our first panelist is who actually orchestrated this panel for us. We want to thank her, Attorney Nicole Bates. Attorney Nicole Bates, she has practiced over 17 years with an emphasis in family, juvenile, and criminal law. She has an extensive litigation experience in divorce, child custody, and child support, as well as juvenile delinquency and other criminal matters. Nicole has also served as the Chief of Staff and many, many other things for Representative Harold Dutton with the state of Texas. And in that role, she has worked extensively and successfully in getting many laws passed today that have affected, and that are, affecting our lives. Also, we're so proud to have the Honorable Angela Graves Harrington with us today. Judge Graves Harrington was the founder and managing attorney for the law offices of Angela L. Graves Harrington, where she focused on civil, family, and criminal law, giving her a wide range of experience. This experience, coupled with her dedication, has allowed her to earn licenses to practice law in the state of Texas, the Southern District of Texas, the Western District of Texas, and the Fifth Circuit Court of Appeals. She started her college career at Mississippi State University, where she received a full ride for her academic success, and continued her education at Jackson State University, and then on to Thurgood Marshall School of Law, where she earned her law degree on a full academic scholarship. Also, although not a Thurgood grad, but definitely a friend of Thurgood Marshall School of Law, we have attorney Jonna Teal. Attorney Teal received her JD from the University of Tulsa College of Law. After law school, she has worked as a civil trial attorney in Harris County, Fort Bend, and several other contiguous counties. She founded the Pro Se Legal Clinic, and this is a clinic that provides representation for those who cannot afford it. A very exciting thing about Attorney Teal is she's very entrepreneurial. Outside of practicing law, she has several other businesses, and she's very active in a lot of different professional associations. And last but definitely not least, the only gentleman on the panel, we have attorney Dan Scarborough. Dan had earned his law degree from Thurgood Marshall School of Law. He has been licensed in the state of Texas since 2011. He practices business, consumer, family litigation, commercial litigation, personal injury, real estate, and wills and trust law. And he is also a member of the Texas Bar College. So if you all would please join me in welcoming our esteemed panelists, and I'll turn it over now to Judge Graves. Thank you.
Good afternoon, everyone. Thank you so much for joining us this evening. We are actually going to talk to you about the issues and the solutions that we've encountered as a result of COVID. So I wasn't expecting it to be turned over to me, but I'll gladly accept the challenge, and we can begin the presentation. Attorney Dan Scarborough will talk first about the background orders from the Texas Supreme Court. The Supreme Court actually had to issue emergency orders because of the coronavirus and the fast-paced changing of our courts in the ways that we have to do things. And so they had to issue orders pretty quickly. And as I know all of you realize or recognize that we had a lot of orders that came out, I think 26. But it was ever evolving because situations and issues will arise and they had to come to quick resolutions. But as you'll see, as Attorney Scarborough goes through the orders, they identified issues and they identified some mistakes that they may have possibly made along the way in the initial orders that were issued. So Attorney Scarborough, I'm going to hand it off to you now.
Thanks for having me here. the first order that we really want to talk about is the second emergency order. It was the first order that had a specific reference to custody and possession and access. And this was an order that was made effective on March 13th and expired on May 8th. Paragraph 2 of this order basically states that this order applies to and clarifies possession schedules in suits affecting parent-child relationship for purposes of determining a person's right to possession of and access to a child under a court order possession schedule. The original published school schedule shall control in all instances. Possession and access shall not be affected by the school's closure that arises from an epidemic or pandemic, including what is commonly referred to as COVID-19 or as the COVID-19 pandemic. You have to remember that this was, around the spring break time when this came out, and that these orders were specifically made to handle the situation at that time, which was right at spring break. Paragraph 3 also says that nothing herein prevents parties from altering a possession schedule by agreement if allowed by their court orders, or courts from modifying their orders. And again, this was the initial language that was used in this particular remedy that the court gave us. Then if we go to the 12th order, which is the next, well, I won't say it's the next order that we really need to worry about, but before this, they use that same language from the second order. But then in the 12th order, they actually changed it, and you no longer had the 2 paragraphs, you basically have the 1 paragraph, which in the 12th order is paragraph 6, and the 26th order is now paragraph 12. And in this one, it states specifically, in determining a person's right to possession of and access to a child under a court-ordered possession schedule in a suit affecting the parent-child relationship, the existing trial court order shall control in all instances. Possession of and access to a child shall not be affected by any shelter-in-place order or other order restricting movement issued by a government entity that arises from the pandemic. The original published school schedule shall also control, and possession and access shall not be affected by the school's closure that arises from the pandemic. Nothing herein prevents parties from altering a possession schedule by agreement if allowed by their court orders, or courts from modifying their orders on an emergency basis or otherwise. And as you can see, this was effective in April 27th, so it was right before school was going out, and some schools had already canceled, but it was basically before we had this new reality of schools where we have, distance learning and things of that nature. And that's where we stand today. The same language that's in the 12th order is in the 26th order.
Attorney Bates, did you have anything to add?
And so I'm sure y'all are wondering, okay, well, what do these orders have to do with my visitation schedule? And so what I will tell you all is how these emergency orders came about in terms of just dealing with access and possession is that I know maybe not only myself, but other attorneys, we were experiencing issues with clients. Clients were not wanting to turn over children. Clients were reading their orders to suggest that, okay, well, if school hasn't resumed yet and technically the kids are still on spring break, then I can keep my child pretty much indefinitely. And believe it or not, some attorneys were even advising their clients that that was the proper thing to do, while some attorneys were essentially advising their clients to follow the court order as you would normally. And so because of this confusion that kind of came about during this pandemic, one of the things that I'm able to do, at least in my role as a general counsel for the Juvenile Justice and Family Issues Committee, is I have the ability to at least get in touch with those higher ups to address some of these issues, address some of these concerns that we kind of see out in the field, and ask that those concerns be addressed. And so that's how the initial order came about, at least the second one. And you'll see that it came out in March, which was kind of right around that time where kids were in spring break and everything was shutting down. And so, you had all this chaos going on. And so that's why we asked the Supreme Court to make some orders on that so that we'd be able to handle it better with our clients and kids would be able to follow just a normal schedule. So how does that affect us now? Were these orders good orders to be put into place? Do we need more orders? Are there other things that we may need in terms of, for instance, pandemic provisions? So generally, we wanted to at least discuss with you all some hypotheticals. One of the first hypotheticals that my colleagues and I discussed was, what if you have a parent who refuses to wear a mask and refuses to require the child, while in their possession, to wear a mask in public settings? What options does the mask-wearing parent have versus the parent that doesn't believe in the mask? And are these grounds, or could these be grounds that potentially could rise to the level of a significant impairment of the child's physical health and emotional development? And the reason that I kind of use that language is because those are kind of the buzzwords that we would use for parents wanting to modify custody orders. And so this pandemic has kind of opened up a lot of areas of the law that we kind of have to start looking at and paying attention to, because the way things are going, you just never know how things are going to end up. And so the first hypothetical is one that we want to address right now with you all.
So at this time, what we're doing is inviting you all to play along, so to speak. We have this hypothetical, and what we would like to know from you all is what you think the options are for the parent, who actually is wearing the mask and following safety guidelines. So we'll give you just a few moments to type in your answer, and then Ms. Suarez will let us know, and then the panel will discuss as well.
Jenna, have you had any clients who have come to you and said, hey, you know, dad is refusing to wear a mask around kiddo, and you know, he has this child all out in public, and I've told him over and over, don't do that, she has to wear a mask. Have you had to have that kind of situation in your practice yet?
Only about every day do I get a client calling in or a potential client calling in discussing whether it be wearing masks, the parent wearing the mask generally, but more overwhelming is more so children being exposed to people not wearing masks in maybe a non-socially distant setting, such as a party or a gathering or an event. So that is definitely something that has come into play. And then from what I can tell from my perspective, being an attorney, not obviously being a judge, is that I think it would come into maybe an issue for a modification, but whether it rises to the level of temporary orders and meeting burdens of significant impairment to the child's health or safety that's going to give a change of custody, now that right there is going to be questionable, because what are we dealing with now? Whether or not people are saying it's religious reasons, they're saying that it's medical reasons, and so it's going to be a slippery slope depending upon, you know, how many cases are probably going to be filed, as far as I think maybe what the courts are going to be doing. But yes, it's definitely an everyday question I'm getting.
What about you, Dan?
What do you get in your office?
Well, I was going to say, as far as I'm concerned, I don't necessarily think it's enough. I mean, it has become more of a political issue now. So, you know, you have some parents who do believe that, you know, there's nothing wrong with you going around without a mask, you know, as long as you keep social distance. So if you stay 6 feet away from everyone, does that still mean that you're impairing that child if the child is being socially distant and also not wearing a mask? I mean, you know, it's more of an issue of whether someone is truly going to use this as a way to try to change custody or get a modification. I don't suggest anybody do that unless there's something egregious where there's a person who clearly has COVID and they're trying to put them in the environment with that person. It's a different story. But just a general fear like that, I don't think so.
But there are those where, you know, you can have your kid around someone if the child doesn't have a mask. There are a lot of people who are positive and have shown no signs of symptoms. They're asymptomatic. And so if you're not having your child wear a mask, don't you think that puts that child's health in jeopardy? I mean, this is a disease that essentially is killing people, and that can potentially kill your child. So don't you think there's somewhat of, you know, a higher burden to ensure that your child is safe and at least not being around the potential for something like coronavirus?
Well, Nicole, and I think that what I think someone else in the when an attendee asked, and I think I kind of agree, is kind of similar to smoking in a car, smoking in an enclosed space, that you're exposing harmful smoke and possible cancer, cancerous type things to a person or to a child. I think the difference, though, would be the fact that you're looking at it from something that can happen immediate versus something that would happen long term. And so I think that, does that interfere with a parent's right to choose as far as what their kids can do or what their kids cannot do? So it's like, can they be around someone who smokes if they have asthma? How many occasions do we have clients who they complain about smoking with children who have asthma? And the asthma can flare up almost immediately, and probably quicker than COVID could.
Right. And I guess are those issues that you're going to want to bring into court? Is that something that we feel the court should be in the middle of, or is it more of a parenting issue?
I think it's a parenting issue.
I do too.
I do think though is, and I have had occasions where I've actually had videotaped parties going on at a home when it was really high COVID area or high COVID risk at that time. And so there has been denials of visitation. I've actually had rulings where the court found no contempt as a result of literally videos of all these people crowded in an apartment with no mask on. Just one occasion though, no contempt. I don't know. I wouldn't chance it in another court.
Okay, and so what is the audience saying? What are their questions?
And so someone is saying something about in Travis County, they have been more likely to change orders if one of the parents or someone in the household is high risk for serious COVID complications. I'm in Harris County, Fort Bend County, Brazoria County, and I can't say that that's going on in any of those courts that I'm practicing in.
Okay.
Okay, so we're ready to move on to talk about the law.
Yes.
All right, so we have, let's see what's going on here. I can get this to cooperate with me.
One of the panelists believes that the mask wearer should be able to get a modification because the best interest of the child is definitely being impaired by the non-mask parent, and the court should do temporary modifications until a vaccine is released. What do you all think about that?
So one thing that I will say that courts do consider, I mean, we have to consider the best interest of the children, right? And considering the best interest of the children, we do have to look at the actions of the parent, and are those actions actually actions that would help or hurt the child, right? So we have to look at the emotional and physical needs of the children. We have to look at the emotional and physical danger of the children, to the children now and in the future. And so courts have a lot of discretion, right? It's really up to the attorney to craft their argument in a way that convinces the court that it falls within the Hawley factors, or, if there is a potential for a 157 enforcement to be, Texas Family Code 157 enforcement to be brought, how could you defend that? Some attorneys will advise their clients to just go ahead and keep the child and risk it. But what's important is that, what's important to know is that case law will tell you that you can't rely on the advice of your attorney for a defense. So a defense to an enforcement, a 157 action pursuant to ex parte chambers basically says that, your attorney's advice may be a mitigating factor, but it's not a defense. So as Attorney Till said, sometimes we, in the moment when when I say we, because I'm not far from removed from practicing, but you will advise your client based on emotion, but and this is something you have to think about ethically, right? You have to advise your clients based on the law, and you have to remove the emotion from it. So, there are several options that you can take. There are several routes you can go. Someone mentioned the modification, and then Attorney Bates mentioned the modification in as far as the temporary orders and the 156 temporary modification of conservatorship if the actions would significantly impair the circumstances of the child. And that's an argument again that you can make. You can bring in expert opinion. You can bring in experts to give expert opinions on whether or not this child will be significantly impaired because of the lack of mask wearing, or you can bring in other witnesses. It's really up to you how you present your case. But those are great comments that you all are making regarding the possible modifications. And again, just make sure that if you advise your client to halt or stop the visits, that you have thought it through very well and that you are ready to vigorously defend it, because these are quasi-criminal, and I don't know why we call them quasi-criminal, because they are criminal actions, because your client can go to jail and be fined. So just be careful in how you advise your client. Again, your client cannot rely on you for defense, and so just be careful with that.
How well do you all think injunctions would work?
Judge, we have a question by Rhonda Harrison. What if the non-mask wearing parent is planning to host a large family gathering for Thanksgiving? That places the child at risk.
One of the attorneys can take that.
It would seem that just having a large gathering in itself would not be harmful to the child. You don't know exactly where the child is going to be, how big the space is. So without knowing more, I would not advise, my client with just knowing those facts to try to go and file something before Thanksgiving, as if they could actually get a hearing date before that time.
Mm-hmm.
You would just need more. Now, if it was something that happened after Thanksgiving and you saw something posted on Facebook and there may be some exchange of the child and no one had mask on, then I think you might have a little bit better case. But without knowing it, just based upon that set of facts, I don't think that you have enough factual information to file anything.
Now, because I was going to say, you could have a large gathering with people who are still socially distanced. So you could, for instance, if you have like an outdoor kind of dinner or something like that, and you have people socially distanced, I mean, that's not significantly impairing a child or anything of that nature. I mean, they can still exercise some precaution, and they're taking those precautions to protect the child, and weighing that versus the desire and the need for them to have social interaction with their family.
And then Dan, even what about the people who have their own set of people that they deal with? Like, let's say there's 5 family members in different households and everyone practices straight social distancing, everyone's virtual school, and then they come together without masks. I mean, I think without knowing exactly what everyone in that family is doing, I think it's hard to say just you cannot allow people to be around, because everyone might be isolating themselves and then coming together. Those isolated same people are coming together, being in the same isolated event, but it just could be a larger isolated event.
Not to mention, everyone may have already pre-tested and all tested negative to ensure that the family gathering, no one would come in with a positive result.
Yes,
That's
and I think this discussion is really great because it shows the thought processes that the attorneys actually have to go through before they make that decision to even file. And then sometimes we have cases that are filed on an emergency basis. And as I think it was Attorney Till said, our dockets are packed. And so when we get an emergency order and it's written in such a way that it's like we have to halt everything to bring these people in and hear this case, and then it's something that's really based on emotion or fact, I'm not going to say it upsets us, but it really upsets the flow of our docket because we set our dockets in a way and such. We try to hear the most important cases or the most urgent, because all of them are important first. And sometimes that will disrupt the flow of our docket if we receive a request for an emergency hearing based on a hypothetical such as that. If someone may be going to have a large gathering. But that's not to say that you cannot come into court with your expert to explain to the court why, even if XYZ is happening, this still could significantly impair my child's emotional or physical well-being. So it's really up to you to represent your client. Just really bring it to the court, whatever it is. But don't fluff up your case, okay? Don't fluff it up to the point where it's actually wasting the court's time, so to speak.
And then just remember also that there's attorneys out there that would say, objection calls for speculation.
Yep. So delving into our next hypothetical, what about when a parent tests positive for COVID-19 and that parent still insists on having his access and possession of the child, knowing that they've tested positive, they may or may not have completed their quarantine period, what options then does the uninfected parent have? And should the uninfected parent should the infected parent file an enforcement for their access and possession if they're being denied that access and possession due to their own positive results? What does the panel think of that?
I might get in trouble for saying this, but I'm not going to advise my client to turn the child over to a parent who is positive. And that's not emotions, that is just best interest, I think. And then you also talk to your client. At the same time, your client is probably going to weigh selfishness over best interest. And I think that it's going to always be overriding factor of it's in the child's best interest to not be with an exposed person or someone who's I'm not going to say exposed, but someone who is actually positive over, a weekend, offer a makeup.
Right, exactly. And Dan, what about you? What would you do?
I would agree with that. I mean, I think there's a definite difference between when people have kind of like a generalized fear versus a situation like this where you actually know that the person is infected. I mean, I don't think anyone would put their children through that. So I definitely wouldn't. And anybody who told me that they needed to do that, I would be more than willing to represent them and say, okay, let's do this.
Okay, so I think we're all in agreement. And I think we may even feel that way simply because we're also parents. And we do know the dangers that this disease carries. And so
you should also act in good faith, Nicole.
I agree.
Also offer.
I agree.
They need to offer makeup.
Absolutely.
Yeah.
Absolutely. Always offer makeup visits. Always. You can even ask them for if they like an additional weekend, considering that they've missed this one weekend.
Right.
But if you have that parent who just adamantly refuses to agree to a makeup visit or agree to an alternate weekend, then what do you do at that point? Okay. All right. I think we're kind of in the same boat there. So what about where you have shelter-in-place orders? And let's say that one parent resides in a county with a mandatory shelter-in-place, while the other parent resides in a county that is not under any shelter-in-place order. For instance, Harris County was under a shelter-in-place order, and Montgomery County was not. And it's not uncommon to have parents who live in completely different counties. What do you all think the outcome of the exchange should be? And how do you think parents should facilitate exchanges? Because obviously, based on what the Supreme Court has said in their orders, access and possession carries on. You still follow the schedule. No matter if there's a shelter-in-place order in place, either way, you still follow your access and possession schedule for that parent. So what do you do to exchange child for the children?
Attorney Nicole Bates, we have a question.
Okay.
What if the tables were turned and the custodial parent has tested positive for COVID? Should the other parent insist on the child staying with them until the parent is negative?
Has that, well, I guess it would depend on what the status of that child is. Because if the custodial parent is positive, more likely than not, that child may already be positive as well. And so I guess it would depend on, or at least, and I'm answering as, I guess, how I would advise a client, it would just depend on what that status of the child is at that point. If the child is negative, then, you know, I would probably advise a client, go ahead and send that child over to the parent that's not infected until you can quarantine and you're no longer infected. That's the best way to do it.
And I think that you also need a little bit more facts. So, because I'm not sure if the person is asking if the non-custodial parent has the child already in their possession and there's the custodial parent has COVID, are they not going to turn the child over? So without maybe a little bit more detail, I think it's kind of hard to answer. But if it was the custodial parent has COVID, but the child is with the non-custodial parent and then finds out about the positive parent, I think technically the custodial parent could say, give the child to so-and-so because it's still her or his superior right of possession.
Right.
And if the child is with the custodial parent who has it, then the child then is exposed. So they would need to be quarantined anyway.
Right. Attorney Johanna Jasmine says, I would not advise a non-infected parent to turn the child over to an infected parent. No, the infected parent should not file an enforcement. And then another comment from Jared Umbles. If the uninfected parent has the child at the time, they should keep the children and potentially get law enforcement involved if the infected parent is trying to force their possessive rights. All enforcement options by the infected parent should be denied.
I don't know about getting police involved. Judge Harrington, does the court have a position in terms of when you get law enforcement involved in these types of situations?
Yes, and like, you know, the court's position is that it's not in the best interest of the child to have law enforcement involved. When parents are in the middle of any type of conflict, the child is already feeling that and suffering trauma as a result of the conflict between the parents. And when you bring in a police officer, a law enforcement officer, it kind of heightens that traumatic experience that the child is already going through. And so, you know, I can't tell you what to do, but I can tell you what I did when I was practicing. I would just let the courts handle it. Is it more important for you to have that child or your client to have that child at that exact moment? Or is it more important for you to have the courts explain to the other parent why they can't be, they can't keep your child from you, and then you get your child later. Sometimes you have to remove again the emotions and the egos and just let the courts take care of it and avoid having the child involved if at all possible. If it's an emergency, entitle your motion, emergency motion for XYZ. That draws the attention of the court. We know to look at it immediately. If we have to bring you all in, we have discretion to call the parties in less than 3 days. And, there is a 3-day rule there's a 3-day hearing notice requirement, but the court can call you in less than 3 days if it's an emergency. So, let the courts handle it. Don't get law enforcement involved unless it's absolutely necessary. If there's a situation where the child's life is extremely in danger, that's different. But this court's position is that it's best not to traumatize the child by bringing law enforcement in.
Okay, thank you. We have another question from Ms. DeFang. What if the child is positive? Do they stay in the possession of whomever has the child in their possession?
Who has the right of possession? At the end of the day, I think that the Supreme Court mandates that you follow court orders. And so if that's, the person with the superior right of possession has someone pick up the child on time, I think regardless if they're infected or not, you've got to abide by what the court order says. And you would assume, though, that if this is the infected parent, they're not going to actually get the child with them and keep them, but could they have a grandparent have possession of the child, or a sister, or someone else? If they have the superior right of possession, that's what my advice would be.
Okay, thank you. We have one more question from Andrea Marsh. I agree during the quarantine period, but would you advise clients to demand a negative test before turning the child over? Would it depend on availability of testing in the community at that time, given that testing availability has varied a lot over the past few months, and turnaround time for test results?
I mean, having a parent go ahead and get the all clear with a negative test is always a good idea. I think it helps both parents feel better about the situation. But again, you still have to follow the court order, no matter what the outcome is, really.
Right. I mean, you can't unilaterally add terms to your contract, which is your order, right? You can't, if the order is that you have to surrender the child on this date, then you have to surrender the child on that date, unless, and then you have to show the court, why do you have this affirmative defense or this defense to relinquishing the child? But you can't automatically on your own make demands. You can ask the court to put, as I think Attorney Bates was saying earlier, injunctions in place for things to not occur until other things do occur. But on your own, you can't just demand a negative COVID test.
And I think also that not only does the Supreme Court mandate, plus the standard possession order, or whatever possession order there might be in an order, is going to say absent mutual agreement. So you kind of have an out there. If you can agree, try to work it out. But if you can't, you have to follow the mandate and or the order.
Yeah, I think that's when it comes down to, parents being parents. I mean, the law can only do so much, and really in these kind of situations, we as parents need to get together and work this out. Yes, you can go to court for some of this stuff, but really it's much better if you're thinking about the best interest of your child to do what's right for the child. And sometimes that means, making up time or doing whatever,
But the truth of the matter, Attorney Scarborough, is that most of us would be out of a job if it was that easy.
That is true. And what?
It was that simple. And while we would love for everyone to be able to do that, the truth is, I know you all see it in your practice, I see it on the bench, each side is grounded. They're, firmly grounded in their positions, and they're not willing to give. And so sometimes it does, require court intervention.
And at the end of the day, sometimes people are really scared to actually go outside of the order because they're fearful that the other person is going to use that against them and then try to file a change of custody, a modification. So you have those underlying issues that usually tend to pop up that keep us in business also.
And always get your agreements in writing. Email one another, text one another. Make sure it's in writing so that it's clear to the court, if you do have to go to court, that there was an actual agreement in place.
Mm-hmm. Yes, because one thing about enforcement, criminal contempt requires willful acts. So if you have an agreement, and sometimes parents will do this, they will come up with an agreement and they get upset with one another, and then they just break the agreement. Or they will bring the other parent into court and say they violated the order. And if the other parent is saying, well, we've always had this agreement and we've done this, but then there's really no proof of it, even there's no written exchanges, text messages or anything, then you really technically your client could be in contempt of the order, even though you had this agreement. So it's just best to get everything in writing.
So our next hypothetical, which is hypothetical number 4, deals with interstate travel in quarantine. Say a parent wants to spend their Christmas break in Belize. The parent makes flight and hotel arrangements, gives notice to the other parent as required, and secures the passport for the child. Parent subsequently learns that the child must have additional necessary documents complying with state and local or state and national health travel requirements, such as a record of vaccinations or a negative COVID test. Parent knows child tested negative 3 days prior to the trip, but non-traveling parent refuses to provide traveling parent with a copy of the results. What is the best course of action for traveling parent?
Get a
Lucille?
refund ticket. I don't think that. I know when we went over some of these hypotheticals, Nicole, and I have the same position. I think the court order, especially Texas orders, are very, very clear, very detailed and specific about how you turn a child over, what time you turn the child over. What they don't have is if there's extra things that you have to provide,
Right.
that is not in there. I think that could be an out for a lot of people. And I think we talked about maybe, they're, putting some additional work. And I think this is going to be the ethics part of this CLE, putting some extra wording in your language, your orders now, whether it be new orders or temporary orders, that's going to actually include pandemic type language, like catch-alls or different things that might happen.
Right, exactly. And Dan?
Yeah, I agree. Exactly. I mean, we've talked about this before, and it's one of those situations where you're kind of tempted to want to try to add some new things. Well, you have to do it, but you just can't. So that's all there is to it.
However, though, let's say you have a pending modification, and let's say you're going to mediation. Those are some of the things that you could potentially bring up in your mediation and ask and see if you all can come to some type of agreement as to what we call pandemic provisions. Something that's just a catch-all for parents, at least going forward, because I think none of us know when this is going to end. And so it's better for us to all be prepared, especially with orders that we're in the process of drafting or going to be drafting in the future. It's always good for us to always be prepared for these types of things.
Yeah, I think that with everything that we know and how long this is going on, and because this is possibly indefinite, that we owe a duty to our clients to actually come up with language and make sure that you include language that's going to deal with travel, mask, being around people, all the things that we've talked about in the other hypotheticals, and including this one, passport, whether the child's going to travel or not travel. And because you got to also think about if they're in Belize, are they going to have to then quarantine for 14 days or something like that?
Right.
And they can't get back in? Are they going to get back in New York and can't get back to Texas because they have to quarantine? Or you're going to also need another test before you enter the United States. How are you going to get that test? That's, So you have to now, you owe a duty to actually be more diligent in drafting your orders.
Yes. And that's so one thing that this pandemic has done is required everyone to be more diligent. I think the bench, the judges have to be more diligent in the way that we look at things and the way that we read and review things. Attorneys have to be a lot more diligent. Nothing against ProDoc, but you can't practice through ProDoc. I can always tell a ProDoc order because sometimes the language is so vague. And the first thing I think is like, wow, when they come to court to try to enforce this, 3 years down the road, they're not going to be able to enforce this order.
Right.
So this pandemic, as Attorney Till has said, it is forcing those of us in the legal community to just be more diligent in our work and in our studies, because we have, new case law that's coming down the pipeline. We have emergency orders that's coming down the pipeline. So you can't rest on the laurels of, I read the Texas Family Code, last year. No, stuff is happening, and it's happening quickly. You have to stay on top of it because, again, ethics, you have to be competent in your practice, right? And so if you're not, you can be held liable for that, and you don't want to face the bar for not being competent in your practice and advising your client and causing some type of harm to your client as a result of that. So one thing I was going to say about this particular hypothetical, this is something that, I honestly don't even know how you would craft your order, because to enforce an order, it has to be extremely specific. I mean, there can't be any room for any other interpretation of the order. And so if it, you get creative. I would love to see some come through with some creative language in it, but just remember, it has to be specific. It has to be a violation. When you're alleging a violation of an order, it's just like an indictment. It has to be on point specific. So.
And the funny thing is, I had a case some years ago. The kids are now over 18, so I can talk about it. But years ago, where dad would not allow the kids to travel to mom who lived out of state. We literally had to draft, it was about a 3-page order that included anywhere from having the child get out of the car, having the child go to the ticket counter, to having the child's ID, to hand that child's ID over to the ticketing agent, to having the child surrendered at the boarding gate, to the boarding gate into the seat, exiting. Literally, it was step by step by step. So we literally went through United's unaccompanied minors protocol.
Mhm.
Basically just had to incorporate those things and make it really tight. But when when he actually denied visitation, we were actually able to get contempt based on how we drafted it. It's very tedious, but you have to sometimes be tedious.
Right.
Your orders.
Agreed. Absolutely agree.
Excellent lawyering, attorney. That's great. You know, I've seen cases where parents are saying, you know, they refuse to surrender the child, and then, you know, we have laws, we have courts in San Antonio saying one thing, courts in Dallas saying one thing about what is surrender. So
Right.
again, you know, this is your time to step up and be a lawyer, and you show the court why your client is not in contempt, or you prove to the court why the other person is in contempt. And it's fun. I mean, it's great. This is out here for you all. It's not a game, but it's exciting to be able to be so creative in your line of work.
And the last thing I'll say on this topic is, in regards to you having to have it or wanting it in your order, make sure that you actually incorporate it into your pleadings.
Yes.
Absolutely.
Yes. And you can make an oral amendment. Yeah, I'm sorry, I'm not going to.
That's good stuff.
Yeah,
You can.
Okay. So that was the fourth one that we.
Yeah, and so I'm going to skip on down to the 6th hypothetical, which deals with school schedules.
Okay.
This is virtual versus in-person school, and this is something that I actually learned from my wonderful colleague. I didn't realize that, and my child is actually in person right now, but her child is in virtual, and they have completely different ending times. And if most of you know, the court orders that we have in terms of access and possession, a lot of times that visitation period may start upon the school being dismissed. And so if you have a school that's being dismissed at different hours, and different schools are apparently doing different things, how do you handle that? And so this hypothetical essentially says, original school calendar posted in spring 2020. Child attends virtual classes, which ends 2 hours earlier than the published school calendar. Is the visiting parent allowed to exercise visits when virtual school ends? Or is visiting parent required to wait until the time published on the school calendar? What is the best practice for parents with one child in virtual school and another child in in-person school, which dismisses at different times?
Very interesting. I think that the mandate initially, when we talked about this earlier, and I don't know if Dan, can you put that mandate up that talked about the
Original published school calendar?
The original published school.
Which order was it? 7, 12?
That was under 12. Emergency
Okay,
order
all
12.
right. I'll pull it up.
Yeah, there it is. The original published school schedule shall also control.
Okay, so then that's the question. When you said the original published school schedule, so in my interpretation of this, I think they were looking at the actual school calendar as far as the beginning time and ending time for spring breaks, the school year. But are we now interpreting that, or need to interpret that, for the beginning time for school and the ending time for the school day? So the issues would be, for example, virtual school starts at 8 o'clock as opposed to in-person school starts at 8:10. What time is the father supposed to turn, or the non-custodial parent, turn the child over? The school day ends for the virtual child at 12, for the in-person child at 3:10. What time is the end of the day actually end for the child? what was the Supreme Court's intent on the original schedule? Nicole, I think there needs to be a change.
Absolutely, and I think you'll probably see a bill that's proposing a change, so that it's clear and we have more clarity in terms of what's intended for possession upon school being dismissed. So, does anyone have any ideas how, practitioners can advise their clients on how to deal with these types of circumstances, especially when you're dealing with perhaps two children that are visiting and each child gets out at different times? Then what? Dan, what do you think?
Well, I think that in general, because it says that, even though it says the schedule shall control, I think that for the most part, the schools have published new schedules that have like the virtual schedule or the in-person schedule, because there are some schools that actually do both, where they do a virtual or they do an option for a in school. And so I would imagine that based on the language, if it says that it's that the possession starts at the dismissal from school, it's at the time that the school is dismissed, whether that be virtual or whether that be in person. But
what if they're different times?
Right.
Then one kid will be dismissed at one time and the other one will be dismissed at another, depending on what they're doing.
But what if the in-person kids are being dismissed at one time and your child's in virtual and they're getting out earlier than the other kids that are in their same class, but they're just in person? Then what?
Then because that the parent has opted for that, I think you're gonna get some special time with your kid, a little bit extra, as opposed to the other kid.
The thing is, I think, and it's my opinion, it clearly shows that there's ambiguity and that you could not, and again, I don't want to give any advisory opinion, but I can tell you, it clearly states that the order has to be reasonably specific. There's no specificity here because one person is interpreting it this way, another person interprets it that way. That means that there's ambiguity. And these are the times where you have parents who can work together and you can massage the cases. It's probably best just to get the parents to work together because outside of that, an enforcement of this nature from this language will be kind of difficult.
And Jana?
I think there is, like she said, I think definitely it's ambiguous and it's definitely hard. Like I think the example that I used was pretty much like my child's schedule. The problem is that on the websites for the independent school district or for the school, it still lists the normal beginning and ending time. Mm-hmm. So if you're a litigator and you're advising your client and you don't actually have all of their asynchronous versus synchronous schedules and things, then you're looking at what is the published school district schedule, even though that might be different for each individual school. And so when the drop-off time is, like I said, my child's school starts at 8 o'clock, but her in-school classmates start at 8:10. So what time would that person be required to drop off?
And your argument also could be, and I think you said this earlier, Attorney Till, is it the bell schedule or is it the vacation schedule? What is it? Is it the entire schedule for the school year in terms of the days that they're out of school, and that's how you are to look at this? Or are you supposed to look at it as the time that school is let in and dismissed every day? So.
And someone asked, what is the ambiguity in the originally published school schedule? And I go ahead, if somebody else wants to touch on that, I think there's different interpretations in the intent of what was discussed.
Right. Well, the ambiguity is that the school may publish one schedule, but they're not following it because you got virtual students following completely different schedule than those that are in person. And so therein lies the ambiguity. Which schedule do you follow?
And exactly, if you're talking about an original school schedule, then my child initially started she goes to school for 9 o'clock. Now she goes to school at 8 o'clock. So what does that mean? If there's no ambiguity, then this visitation start at 9 o'clock because that was the original school schedule.
And so I guess what we're saying is that it's up to you as a lawyer to, to let the court, to argue your client's case. You really could say that the original public school schedule, is the school schedule, is the days that they're in and out of school. It's the spring break days. And then, some people can argue that the original public school schedule is the bell schedule. What time does school start every day? So that language has to be crisp. There can't be any room for ambiguity, again, because these are criminal actions. People go to jail and they have to pay fines. It's just like a criminal case. The criminal cases is beyond reasonable doubt. You cannot leave open any interpretations when it comes to the enforcement of these orders.
Right.
And that also takes me to another subject which we haven't talked about. But what happens when you have these situations in our orders where one parent is making the decision on it or making the educational decisions, but they have to consult with the other parent, or either they have to agree. And let's say one parent wants the child in virtual, one parent wants the child in person. That's an issue that typically, from the most part, if parents can't come up with their own solution, will end up in court as well, especially if you don't have a tiebreaker. And most tiebreakers are not trying to get in the middle of that particular decision concerning educational decisions right now during COVID. Most of them are not trying to get involved. So then what do you do? Ms. Till? Dan?
I think for the most part, you have situations like that, it really does come to parenting. I mean, I know that doesn't make us money and that, and create the necessary things for litigation, but I think it does have to do with parenting. Parents have to work together, especially during a time like this. I mean, more so than any other time, I think they need to work together to kind of sort this stuff out.
And I think it's also important to know that if you have something about joint agreements and there's no tiebreaker, most likely that was something that was done in mediation or by an agreement. And that means that you if you cause that situation because you have no tiebreaker in there, then you have to kind of work it out between the parents. But most times I don't, as an attorney, I'm not going to have certain language in my orders if I know the parties historically don't get along.
Right.
I mean, so it comes down to how to properly advise your clients on certain things so that way they won't have those issues. And then you also need to always think about there should always be a tiebreaker.
There should always be a tiebreaker. But what happens then when you have that situation where the order does call for a tiebreaker, but the tiebreaker absolutely refuses to get in the middle of it? Because essentially we're dealing with COVID. We're dealing with potentially someone's right to protect their child. Maybe they don't want to send their child to school for in-person and they want to keep them at home, but you have another parent who insists on them going to school. The tiebreaker, 9 times out of 10, is not going to want to get involved in that. So then what do you do?
Well, the attorneys actually, or the litigants, a lot of times will send emails and things like that to the school officials and whatnot, and not make it appear as if, oh, can you be the tiebreaker? It's simply going to be, well, what do you think? What do you recommend? And you're going to get something before they realize that you are being set up to be the tiebreaker. You're going to get something from someone that actually is going to give some guidance on it that the parent's going to use. I think that's generally going to be the case.
So what I've been seeing lately is that the tiebreakers, I don't know if they've been given legal advice, but they are not, even if it's an email saying, school is in and I'm wondering, should I send him, they're not giving advice. I don't know what it is. Maybe they probably have been advised because it is put in the school. Now the schools are becoming liable because they're advising or almost forcing an issue, and then that child is forced back into the school, and then it's becomes COVID positive, then there's another issue there. So I can understand the tiebreakers not wanting to be a part of it, and I think it's like Attorney Till said in the very beginning, you just have to know your parents and don't just name a tiebreaker. Talk to these people and be sure that they are willing to serve as a tiebreaker, because the courts have no authority to force anything on to another, onto a third party. So we can't enforce them, hold them in contempt for refusing to be the tiebreaker. So talk to them and make them, aware that they are being named as a tiebreaker. Otherwise, it's not wise to just throw people out there like that, because when they're brought in to actually have to testify about it, they will not be happy if they realize that they've kind of been tricked into something.
Yet we do it all the time in terms of those tiebreakers.
Mm-hmm.
Typically, we're going to have them in there.
But the good thing is that it's normally a general statement such as the applicable school official or
Right.
the child's primary pediatrician or something like that.
Right. Well, you guys, I think we've reached our hour. And I want to thank you all so very much for joining me in this discussion. I respect and admire all of you, Dan, Jonna, Judge Harrington. I respect and admire you all, which is why I wanted you all to join me in doing this today. And I hope that the participants got a lot out of this discussion, and hopefully, it helps them somewhere along the way. And anyway, just want to say thank you guys.
Thank you.